The word feasible is an interesting one here. It's a somewhat malleable term. To put it on a gut level, the idea is a plan is feasible if the debtor has the resources to consummate the plan, to make the payments, to make it work. But there are a lot of moving parts here. So in the answer to the last question, I said that creditors are put into these various priority classes and they have to be paid according to the order of priorities. And so if the debtor has insufficient income, insufficient assets to liquidate to make that happen, then we can say this is not a feasible plan because you cannot satisfy the requirements of payment to the creditors that are found in the bankruptcy code. Now, there is another bit of a wrinkle here. I mentioned the priority classes, and I also mentioned that there was a class below the standard priority classes, and that's the general unsecured creditors. While the priority creditors typically have to be paid in full, the non-priority general unsecured creditors don't necessarily have to be paid in full. So how does this work? Well, one of the requirements of a Chapter 11 plan is sometimes referred to as the Chapter 7 liquidation requirement. In essence, what it says is, over the life of the plan, the debtor must repay the general unsecured creditors at least as much as those creditors would have gotten had the debtor done a Chapter 7 liquidation. And we like to think of two versions of Chapter 7 liquidation, one for businesses, the other for individuals and legally married couples. So let's start with the individuals and legally married couples. When an individual case, when an individual files a Chapter 7, the goal is just to erase debts without making payments to creditors at all. And of course, from the creditor's perspective, that's a bit of a hit. So there are some limitations. One limitation is on what the debtors get to keep. So the debtors get to keep some stuff, but there's at least the potential to lose assets in a Chapter 7 bankruptcy. So one of the things we include in a set of Chapter 7 bankruptcy papers is a complete listing of everything the debtor owns or has an interest in. And all of those assets get divided into two categories, exempt and non-exempt. The exempt stuff, that's the debtors. The non-exempt stuff is fair game for the Chapter 7 trustee to seize, liquidate, and have money to pay creditors. In a Chapter 11, the debtor doesn't lose assets unless it's part of the plan. But we still go through the exercise of listing all the stuff, dividing it into exempt and non-exempt categories, because whatever the dollar value is of the non-exempt assets is the minimum that the debtor can get away with repaying the general unsecured creditors over the life of the plan. Generally, though, it's a wise move to give more to the general unsecured creditors than just that bare minimum, because you want to maybe induce them to vote in favor of the plan. And if all you're giving them is the bare minimum, they might not be particularly motivated to support your plan. So that is an important requirement in a Chapter 11, the so-called Chapter 7 liquidation requirement, sometimes referred to as the best interests of creditors requirement. That, I think, can also go into the feasibility analysis. Does the debtor have enough in income, in liquidatable resources to be able to not only take care of the secured claims and the priority claims, but in addition to satisfy this Chapter 7 liquidation requirement? And so in a plan, the debtor is going to provide a very detailed breakdown of assets, income, expenses, and a bunch of other stuff so that the court can get some sense of whether or not this is a feasible plan. And if it isn't, the judge is going to say, I don't care what you have to say. This is not feasible. You can't satisfy the requirements of a Chapter 11 plan. Now, I should add one additional comment here, and that is if creditors accept less favorable treatment, let's say Priority creditors decide, we'll cut you some slack. We'll vote in favor of your plan, even though you're not going to pay us according to the requirements of the bankruptcy code. Then that might make the plan feasible after all. So sometimes a little sweet talking can be handy in this situation. There is a limitation on being able to solicit votes prior to the judge approving the disclosure statement and ordering the debtor to send out the plan. But once that's done and the creditors have good information, sometimes a little telephone law can help out. Give the creditor a call and say, I realize that this might not be exactly what you're hoping for, but let's consider the alternative. If I go into Chapter 7, well, you might not get paid in full. I think this might be better for you, even though you might be entitled to more. So that can also overcome the issue of feasibility. But in essence, if I can circle back to the original question, feasibility is the plan is feasible if you have the resources to make it work.